Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome Monday. Monday has been very, very busy for me. I'm up here fighting for my life and regarding Tony Busby, and I was like, okay, look, I gotta kind of get to my other cases, but hopefully y'all pretty much understand what's going on with Busby. So moving on to Jay-Z's partner in crime, Mr. Sean Carter, there has been updates in his case, and y'all gonna find this very, very interesting because this dude is trying to suppress evidence that was obtained during the raids. And I'm like, why? So we're going to get into the motion to suppress his particular motion, or his what we call like a memorandum in support of that motion. And then also we're going to tap into the declaration of Tini Guerreros, and I hope I'm saying his name right. But Tini is an associate of the Agnafilio law firm, and Mark Agnafilio is the attorney that is representing Diddy in the criminal case. So Tini has been um, I want to say appointed as the person who sees all of the evidence that has been given from the government to the defense counsel, including the freak off tapes, Cassie's 10 freak off tapes, and also any information that was gained or that was extracted from I forgot how many terabytes of information that was, but all of that has been placed in the possession at the office, and Teeny is the only person who has access to review this, and to he has the access to the passwords because everything has to be on an encrypted device that doesn't have any internet, the whole nine yards. So if anything happens, everybody could blame him. Okay, so he would work with the experts because remember when they were saying that the audio quality wasn't good and the video quality wasn't good, and they had their experts that they want to use in order to kind of get the quality up to par. Well, Teeny is the only one that can work with an AV specialist to get the audio and the video quality where it needs to be. So that way, if they want to use certain things in from that video they can throughout the litigation process and especially during trial. But at the end of the day, everybody, Mark Agnafilio, the court clerk, deposition clerk, the judge, everybody has to follow the rules to ensure that the protected information stays protected. So the protective order that they do have placed has to remain intact until a couple of months, I believe, after, because they have to discard all of that information once the trial is over. But if you didn't catch that, definitely go back and watch the last video that I did explaining the protective order over that. Now, before we get into the motion to suppress, the other day Anthony Ricco filed a motion to withdraw as counsel from uh from the Diddy case, the criminal case, the Diddy criminal case. In his motion, he pretty stated that he has provided Sean Combs with the highest level of he pretty much given his all. He respected him. He did everything that was asked of him, but he felt that if he continued to represent him, that he would violate the American Bar Association rules, statutes, whatever they have set. Somehow, some way, he felt that whatever he was going to continue, whatever he was doing as Diddy's attorney, he would have some type of ethical breach or violation. And that did not sit right with him. And he decided to file his application or his motion to ask the court to withdraw him from the case. In that motion, he did state that he had a talk with Mark Agnafilio We will never know what those talks are about, only because those are a tiny attorney-client privilege. So unless one of them come out and say, "Hey, this is the reason why, Rico dropped from the case," that's the only way we're gonna know. At this time, the only thing that we could do is speculate. As of today, the court states the following. Please take notice that upon the annex declaration of Anthony L. Ricco, uh, that the defendant Sean Combs moves this court before the Honorable Arun Subramanian, a United States District Judge, for the following relief: for an order permitting Anthony L. Ricco Esquire to withdraw as an attorney for record in this case, and for such other and further relief as to the court may seem just and proper. So, as you can see, it was granted. So, the court granted his withdrawal from the United States versus Sean Combs case, effective today. So he will no longer show up under the parties tab, under the defendant, or he will no longer show up as an attorney in the parties tab. And that's it. That's all. So he is officially withdrawn from the case as of today. Now, let's tap into this notice. And it's gonna be like, really? Like, really? Because this is very interesting. This is very, very interesting. Let me blow it up so if y'all want to read along, y'all can. All right, so notice of motion to suppress evidence obtained through search warrants or in the alternative for a Frank's hearing. You know what? I should have pulled up the definition before I even went on here. So Frank's hearing is, I got y'all, give me 1 second. So a Frank's hearing is a legal proceeding in a federal court that challenges the validity of a search warrant affidavit. All right, so keep that in mind. And also, it goes to say that a defendant must prove that the affidavit contained false statements or admissions that were intentional or reckless. Okay, because everybody know that a warrant is an affidavit signed by an official and possibly notarized. As a notary, I know that it's notarized. So what he's saying is that he wants to suppress anything that came out of the raid. Let's read. Please take notice that upon declaration of Tini Guerreros, now this is the individual who is in charge of overseeing all of the evidence that is from the government. So the government gave them all the evidence. Well, not all. They're in the process of giving them majority of it. But all of the items, all of the information, all of the documents, all of that, it is under the protection of Mr. Teeny. So he's the only one as of right now who has seen everything so far. All right. So upon his declaration dated February 18th, 2025, exhibits attached thereto and the accompanying memorandum of law, defendant Sean Combs, by and through his undersigned attorneys, will move this court at the United States Court. Okay, the date and time. So they're requesting a hearing on this motion. Now, here's what they want to talk about. One, they are requesting the court for an order for one, suppressing the evidence and all fruits obtained from the following search warrants. A, January 4th, 2024 warrant to search Mr. Combs' iCloud accounts. B, the March 22nd, 2024 warrant to search his Los Angeles residence and to seize evidence obtained therein. The March 22nd, 2024 warrant to search his Miami residence and to seize evidence obtained therein. The March 25th, 2024 warrant to search his person and to seize and search two of his cellular phones referred to by the government as Combs number 1 and Combs number 2, and to extract information from those phones. The September 16, 2024 warrant to search his person and to seize and search an additional 2 of his cellular phones, referred to by the government as Combs number 3 and Combs number 4. Bro had 4 cell phones, and to extract information from those phones. And F, the September 16th, 2024 warrant to search Combs' room at the Park Hyatt Hotel and to seize evidence obtained therein. And then 2, in the alternative, granting a Franks hearing. So, in addition, he is in not only wanting for them to suppress all of the evidence that they have collected since January 4th, but they are also asking for a Franks hearing to go over to see if the contents in the affidavit is truthful. Now, y'all know when you're dealing with an affidavit, this is the notary side of me talking. You have to hold up your hand and you have to say that the contents in this affidavit are true and accurate. If you say so, if you say yes to that, or you repeat it and you say yes, however your notary does it, you sign it, the notary stamps it, and voila. So I would not be surprised if a notary would be questioned. That's why, for all my notary gang, it is very important that you are ensuring that every notary transaction that you do, I don't care for who, you have it in your book. Because there will be a time, and I teach this in my notary class, there will be some times where you may be called by the court or an attorney to be questioned. Let's continue. All right, so that was their notice. Let's get to this memo. All right. So, memorandum of law in support of that motion to suppress the evidence. So, we already know what evidence that he's trying to suppress, and we already know what they're trying to do at the Franks hearing. They're trying to see if the contents of that affidavit is truthful based off of true information. I ain't going through all that. Let's see. Da 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 da. Ooh, what they say. Search and seizure treaties on the Fourth Amendment. Ooh, y'all, we about to be in for a treat. The government has a duty of candor when it seeks warrants. The nature of the proceedings mandates secrecy so that the process is not adversarial. Precisely for that reason, investigators have an obligation to present a fair picture of the evidence, including both inculpatory and exculpatory facts. While investigators need not present a magistrate with every bit of evidence they have discovered, they must nonetheless include a reasonably even handed account, and they cannot omit critical exculpatory facts that might undermine a finding a probable cause. As the Circuit has instructed, investigators should include evidence if it is the kind of thing the judge would wish to know in determining whether probable cause exists. The government, in this case, utterly failed to do so. It sought several warrants to search Mr. Combs' residence, his electronic devices, and his person, and it presented a grossly distorted picture of the facts. It included only inculpatory facts, and it excluded critical exculpatory evidence that was indisputably in the possession at that time. The government claimed victims were coerced in X, but it failed to inform the magistrate that, ooh, I wish I want to know what that says. Darn it. It also failed to inform the magistrate that it possessed text messages between the alleged victims and Mr. Combs, redacted. The applications were intentionally misleading, which at a minimum requires a Franks hearing. So, whatever was said in an affidavit, they need to see if those affidavits were indeed truthful. The warrants themselves were also grossly overbroad. On a theory that Mr. Combs' entire life was a criminal enterprise, the government sought virtually limitless authority to seize any evidence related to that enterprise, all his digital devices and the information they contain, all the information in his iCloud accounts, plus troves of records and items in his houses, almost none of which was contraband. And they cited United States versus Way, where Judge Nathan found similar warrants unconstitutional. Here, the government obtained authority to rummage at will among Mr. Combs' private effects. Perhaps most troubling, the government received essentially limitless authority to search Mr. Combs' digital devices, which contain a vast trove of personal information. The Supreme Court and Second Circuit have repeatedly warned that it is especially important that digital evidence or digital device searches must be limited and particularized. The warrants here were not. The warrants were thus unconstitutional general warrants, and the evidence obtained through those warrants must be suppressed. Oh my good googly moogly. Let's see what they did, y'all. Let's see what they did. During this investigation, the government executed numerous search warrants. On January 4th, 2024, it received a warrant to obtain all information in Combs' iCloud accounts. On March 22nd, 2024, it received two warrants to search Combs' residence in Los Angeles off of Mapleton Drive and Miami, the Star Island Drive. Both applications were based on substantially identical affidavits sworn by uh, HSI. Is that Homeland? No, I don't know. Agent Sean Quinn. 3 days later, on March 25th, the government obtained an additional warrant to search Combs's person and to seize and search two of his cell phones. Trying to see. All right. Nothing to be reading. All right, so the warrant sought to obtain evidence related to possible crimes of racketeering, ex trafficking, and obstruction of justice. The list of items to be seized at the residence was incredibly broad, spanning pages and including, among other categories, all digital devices found within the residences. The list of information to be obtained from the devices was similarly broad. Similarly broad. There we go. But as detailed below, the warrant applications presented a grossly distorted picture of reality. The government had in its possession, for example, a variety of evidence, including suggesting victim one's participation in the alleged freak offs was voluntary and consensual, not coerced, as the government suggested in its applications. The government's claims, blank, was based primarily on statements from producer one, an utterly unreliable witness whose claims were contradicted by other evidence that the government failed to mention. And the government's obstruction alleged allegations were based largely on text and statements taken out of context, a critical part of the context being that blank. Oh man. Defiant also failed to mention that nearly every witness he interviewed had blank, giving them a financial motive to fabricate or embellish. Ooh. The probable cause statements were intentionally misleading. But it worked. The government got its warrants, leaked damaging information, and then executed its military style raid at Combs's residence. Through the duplicity, the government obtained evidence, including multiple electronic devices with an enormous amount of information about his entire life and an enormous and unfair tactical advantage. It continued to press its advantage, obtaining an indictment and multiple additional warrants, which were incredibly broad. So here is the defense counsel argument. One, the government's warrant applications contain intentional or reckless deceptive statements and omissions. Part of that, warrant applications may not omit critical exculpatory evidence. So they're saying that there was some evidence that was not mentioned on the warrant applications when it went before the judge to get signed off on. Under the Fourth Amendment, a warrant may only issue upon a showing of probable cause. But as then Judge Barrett wrote, the warrant clause is not merely a probable cause guarantee. Rather, it is a guarantee that a warrant will not issue unless a neutral or disinterested magistrate independently decides that probable cause exists. A magistrate can only perform that function if the government provides an accurate and complete statement of the evidence demonstrating probable cause. Under Franks versus Delaware, it states if a statement of a probable cause contains material false and misleading statements or omissions, then the warrant is invalid, and any evidence obtained pursuant to the warrant must be suppressed. To suppress evidence obtained pursuant to a warrant, a defendant must show 1. That the warrant application contained intentionally or recklessly misleading statements or omissions, and 2. That the falsehood or omissions were material and necessary to the warrant's issuance. To obtain a Franks hearing, a defendant needs only to make a substantial preliminary showing as each prong. Uh, Let me see. Let's see, they reference United States versus Loria, where they said that the vacating judgment and remanding for a Franks hearing on the unresolved factual issues. Ooh. Recklessness or intent may be inferred where the omitted information was clearly critical to the probable cause determination. I really want to know now what it is that the government left out. Like, y'all had the evidence, but y'all left. So that means that's the evidence that y'all obtained prior to January, possibly from the Cassie case. Hmm. All right, let's keep reading. As noted, a warrant application can be false either through affirmative false statements or misleading omissions. An application must contain a reasonably complete statement of the evidence, including exculpatory evidence that would be critical to the evaluation of probable cause. Let me see. Hold on, I am looking something up right here. So, inculpatory evidence is evidence that shows a person involvement in a crime. It can be used to establish a guilt beyond a reasonable doubt. Now, for exculpatory, that is where it is evidence that helps prove a defendant is innocent of a crime. Ooh, okay. So, exculpatory is evidence that proves the innocence of the defendant. Inculpatory is evidence that shows that that person is guilty. It shows that that person was involved in that crime. So, what they're saying is that the government left out critical exculpatory evidence that proved Diddy's innocence. All right. Ay, ay, ay. Though an officer need not volunteer every fact that arguably cuts against the existence of probable cause, the officer may not omit circumstances that are critical to the evaluation of probable cause. Let's see. While an application need not include every potentially evocative detail that would interest a novelist or gossip, an investigator cannot make unilateral decisions about the materiality of information or merely inform the magistrate or judge of inculpatory evidence. Simply put, an affiant seeking a warrant cannot withhold important exculpatory information from the magistrate, aka the person who is seeking the warrant cannot leave out evidence that can thus prove that the defendant is innocent. That is pretty much what it is saying. The duty to include critical exculpatory evidence includes a duty to reveal information that undermines the credibility of a confidential informant or other witnesses. When the government relies on witnesses' statements rather than an investigator's own observation, their credibility is plainly relevant, even critical to the probable cause determination. The failure to provide known information that goes directly to the credibility of a witness or informant violates an investigator's duty to disclose. The government made false statements and omitted critical exculpatory evidence in its warrant applications in this case. This omitted evidence was in the government's possession at the time it sought the warrants. The omissions were intentional or, at the very least, reckless. Bay, bay. Whew. The second argument that the defense counsel is making is that the government's warrant applications hid critical exculpatory evidence regarding victim one's consent and financial motive. Well, I already told y'all what exculpatory means, so at this point, we already know. We already know victim one is Cassie. So let's see what they said. So pretty much what they're saying, Cassie agreed to it and she blackmailed him for financial gain. That's the simplest terms I could put it in. The core allegation in the warrant applications, and indeed the government's entire case, is that Combs forced victim one to participate in freak offs. In its March warrant applications to search the residence, it stated, This statement was based on the investigator's interview with victim one, who took place 5 years after the events. But the government unaccountably failed to inform the magistrate, and I'm assuming that they left out, once again, important information that shows that Cassie did this consensually, both of which severely undermine its account. When it sought the warrants to search Mr. Combs' residences, the government had already obtained one device from Cassie, victim one, that contained, and we'll never know what that is. Oh man, oh gosh. Unbelievably, the government did not blank in the warrant applications or even inform the magistrate blank. Faced with a claim of coerced and forced acts, the blank is the sort of thing that any fact finder would wish to know. This was no accidental omission. By the time it obtained the warrants to search Mr. Combs' residence, the government had already obtained blank. Oh, let me see what that footnote is. The warrant application states that the agent had already viewed the Sean Combs Bad Boy iCloud account and the PD Team iCloud account. Ooh. So they already tapped into his iCloud accounts. Once again, these blanks contradict the government's claims that the freak offs were coerced. God damn, that's a lot of redaction. Oh man. Well, it doesn't even at this point make sense for the government alleged blank, but it failed to mention blank. The government alleged blank, but it failed to mention blank. More generally, even as the relationship deteriorated and the two managed a breakup, they are important evidence. They show the context of the relationship. So whatever it is, states that whatever it is that they have that they failed to put in there, it was very important evidence, and that evidence showed the context of the relationship, and they also blank. They are the kind of thing that any magistrate judge would wish to know when reviewing a warrant application in a ex trafficking case. Yet the warrant application contained not even a hint of them. They didn't even inform the magistrate judge that this evidence existed. Oh, God. They simply stated that blank. This was intentionally misleading. Blank contradicted victim's one's later account and gave the investigator obvious reason to doubt the veracity of the allegations. The investigator was thus legally required to disclose them. Something else contradict the applications in other ways too. The application said, "Oh my gosh!" So whatever this is, it told a different story. In the warrant applications, they claim this, but then again, the government hid the evidence to the contrary. Oh, wait. Footnote 3 is a mail escort service. As the motion to dismiss count 3 details, the service has been operating in the open for over a decade. Oh yeah, somebody put that in the members post on YouTube. Yeah, I got to go back and look cuz I was like, this is just a fancy way. Like, y'all are prostitution is illegal. So in order to beat the system, you call them escorts. That is wild. As the government has since conceded in disclosure letters, okay, da da da. Moreover, the government hid evidence that Combs at times discouraged Blank from using so many rugs. Oh, hmm. So, Finally, the warrant applications contain no mention of victim one's financial motive to exaggerate and falsify. As the government knew, thus provided an unusual strong motive to fabricate years after underlying events. Boy, boy, boy. Blank suggests that years after her relationship, she changed her story in a way that would cause maximum potential damage to Combs and thus give him maximum incentives to agree to a large payment. This is exactly the sort of evidence that goes directly to the credibility of the witness, whose story provided the core of the government's applications. As court around the country have held, evidence that undermines the credibility of a key witness must be revealed because the judge must be given the opportunity to assess the totality of the circumstances. Here, rather than giving the reviewing magistrate a fair summary, the government hid exculpatory evidence to bolster its case. The warrant applications were calculated to mislead, omitting clear critical evidence. The third argument the government makes the defense counsel make is that the government's warrant applications hid critical exculpatory evidence regarding the credibility of other witnesses. So they had evidence that is saying that all these other witnesses, they're liars. The government also sought to corroborate victims one's allegation and make related allegations with statements from other witnesses and victims. Again, the government hid evidence undermining the witnesses' credibility and presented misleading and selective accounts. We are not dealing here with omission of a few auxiliary facts. This is a case of systematic deception. All right. Ex worker one. The government relied on information from ex worker one. But ex worker one has also given a statement. Ex worker one has also given the government exculpatory information, none of which was included in the warrant applications. In its December 29, 2024 discovery letter, for example, the government revealed that, ooh, Footnote 5 says the government has refused to provide the defense with the names of the item anonymized individuals named in warrants. Ex worker 1 appears to be the same person disclosed in the letter. Baby, they getting testimony from the ex workers. These statements from a key participant in the freak offs undermine the allegations that, and they corroborate, It is unclear when the government received this information. The government has only stated, something any investigator would have asked. It is also unclear that the other exculpatory statements ex worker one made about. Oh man, this is precisely why Frank's hearing is required to learn more about what the government knew and when. Moreover, even if the government was not yet aware of blank, It could have been aware had it asked. Given the government's loose relationship with the truth throughout its warrant applications, the most obvious inference is that the government was already aware of ex-workers' one exculpatory statements, but simply failed to include them into the application. It did exactly what the Second Circuit Court forbids, merely informing the magistrate or judge of inculpatory evidence. All right, so assistant one. The warrant applications relied on information about assistant one, including. Mm, so we don't know what the assistant one said. The applications failed to disclose, but the applications were particularly misleading in the recounting of supposed obstruction of justice. They stated Combs had obstructed justice by, let's see, but the government cherry picked a couple of statements out of context to imply, but the complete thread demonstrates the opposite. Oh, man. This was not a harassing or threatening exchange. It was rather does not remotely make out probable cause for an act of obstruction, but the government plucked a few quotes out the context and thus presented the magistrate with a completely distorted picture of what happened. The distortion could not have been accidental. It was a deliberate choice. Producer one. So we got ex-worker, we got assistant, and we have producer. Some of the most salacious allegations recounted in the warrant application came from producer one, who the government now says it will not even call to testify at trial. The investigator indicated he had interviewed producer one, and producer one had relayed stories about his time working for Combs. I bet y'all that is Lil Rod. Lil Rod, the very first um petition that came out against Diddy. Mm-hmm. Producer one claimed, among other things, that, but the most serious and specific allegation for producer one was his claim that, oh man, the application state, yeah, we can't get none of these. The accusations were never credible. They were uncorroborated. And the government had boatloads of contrary evidence, including da, 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 da. The government eventually dropped these allegations and later warrants, but their lack of credibility was manifest from the outset. Now, here is the thing about that Little Rod case, right? I remember doing that, reading that lawsuit on another channel holder's channel. What I do remember from that is how Little Rod was talking about, when they were on a yacht and Cuba Gooding Jr. was, trying to come on. He was rubbing up against his leg and stuff. And it had a still image photo of him doing that. Then, fast forward to a couple of months ago, the lawsuit that was filed against Christian Combs. Whatever this yacht was, that lawsuit against Christian Combs was from a person, a young, I don't know if she's young, but from a lady who was working on the yacht. And she was describing the events that took place on that yacht. And I believe she was on that yacht the same time that Rodney was on the yacht doing that Brotherly Love album. So it's like all of these stories eventually come together, like they eventually overlap. That's why I've always said that those civil cases is going to help build up this criminal case. That was my opinion. All right, let's continue. And the government once again failed to disclose producer one's financial incentive to fabricate and embellish. So they trying to say he was out after money too. The government has advised us it will not call producer one as a witness at Combs' trial. Presumably, that is because his stories are fantastical and he lacks any credibility. But his lack of credibility was equally apparent in March 2024, in part based on blank. At a minimum, the warrant application should have disclosed namely his motive to fabricate and to tell the government a story that matches the stories. Oh my gosh. Once again, however, the government hid this from the magistrate. The investigator simply relayed producer one's claims without qualification as if he was a credible witness. So they saying Rodney ain't even credible at this point. Victim two, we don't even know who victim two is. Victim three, the affidavits allege, based on interviews with victim three, that Combs, the relevance of these allegations is less clear. The claims about victim three appear under the header blank. And y'all, if y'all notice, they're calling them by their titles, and not by their names, is because the government has not released the names of these individuals for privacy purposes and safety. In any event, the warrant applications once again include none of the information the government must have known that called into question her credibility with regarding the allegations. Oh my gosh, victim 4. At this point it doesn't even make sense to read this. So they couldn't corroborate victim 4 claims. Designer 1. The warrant application also includes allegation from designer 1. The government has also claimed a representative of Combs have engaged in obstruction when. Oh man. And some 3 critical witnesses on the government relied were all blank. Not only did they have the general financial motive to fabricate, blah 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 blah, blah, that information would have, to put it mildly, raised doubts about their credibility. But the government said nothing about. Once again, it intentionally hid evidence that would have undermined their credibility. The misrepresentations and misleading omissions in the warrants are frequent and patterned. The affiant omitted, for example, all information about all the witnesses blank and financial motives to fabricate. These omissions were related and exculpatory, indicating recklessness. This is a case where the cumulative effect of all of the omissions was to eliminate nearly every indicator detracting from the witness reliability. This is a case where the affiant failed to provide all potentially adverse information and might have undermined a probable cause findings. And they cited United States versus Simmons. I'm sorry. Um, the law requires the government to include all critical exculpatory information in a warrant application. Here, the government included none. Ex trafficking, like child pornography, is so repulsive a crime that those entrusted to root it out may, in their zeal, be tempted to bend or even break the rules. When government investigators cheat to obtain warrants, they endanger the freedom of all of us. In cases like this, it is essential that courts enforce the requirements of the Fourth Amendment, both to protect the individual's rights, the individual defendant's rights, and also to deter this sort of government misconduct. The misstatements and omissions were material. There is no question, based on the above evidence, that the warrant applications contain falsehoods and misleading omissions. The remaining question, the second prong of Frank's, is whether the falsehoods were material. This analysis examines what a hypothetical truthful warrant application would have stated and whether that information would have been supported probable cause. In the case of misstatements, a reviewing court must set aside the misstatements and determine whether the untainted portions are sufficient for probable cause. In the case of misleading omissions, a court must insert the omitted truths and determine whether they undermine probable cause. Here, truthful applications would have stated that victim 1 but also that the relationship was long, complicated, and often loving. They would have stated that blank, 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 and that such a truthful presentation would have provided probable cause for ex trafficking charge or any other federal offense. Still less would it have provided a basis to search everything and anything in Combs' two residences a decade later. Truthful applications would have stated that Combs, da 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 da, that would have stated producer one. Oh my gosh. Let's just get down to where it's not redacted. The government here unfortunately demonstrated a damn the torpedoes full speed ahead mentality. In its zeal to prosecute a famous target, it rushed ahead and violated the law. It submitted a egregiously false and misleading summary of the evidence, thus denying the neutral and disinterested magistrate the opportunity to independently determine whether probable cause existed based on a fair and truthful summary of the evidence. It is presented only inculpatory evidence, and it hid all exculpatory evidence. These falsehoods taken into the aggregate were material to the probable cause determination. Truthful and complete applications would not have provided probable cause to search both of Combs' residences and all his devices. The warrants were unconstitutionally broad. The charges here reflect an extraordinary legal theory that Mr. Combs is himself an enterprise and that his businesses, his household, his personal relationships, his ex life were all part of a criminal conspiracy. That broad theory is alleged in the indictment and reflected in the warrant. The government essentially took the position that everything about his life is possibly evidence of a crime. In a series of warrants, it thus sought authority to search and seize everything in 1. His cloud account, 2. His residences, 3. His cell phones, and D. His hotel rooms. The only limitation that evidence had to be related to the subject offenses, but because the theory was that his entire life was a racketeering enterprise, that was no limitation at all. This case implicates the central concern underlying the Fourth Amendment. The concern about giving police officers unbridled discretion to rummage at will among a person's private effects. That is exactly what the warrants unlawfully allowed. The Fourth Amendment prohibits or forbids general warrants. The Fourth Amendment warrant clause requires that any valid warrant must state with particularity the place to be searched and the things to be seized. The purpose of the particularity requirement was to prevent the government from using broad warrants to rummage through a person's whole life. The chief evil that prompted the framing and adoption of the Fourth Amendment was the indiscriminate searches and seizures conducted by the British under the authority of general warrants. A warrant must, at a minimum, satisfy criteria. It must specify the offense, it must describe the place to be searched, and it must specify the relationship between the items sought and the designated crimes. In addition to those three general factors, there are also circumstance specific considerations that bear on legality. Let's see. For example, a warrant that fails to indicate a reasonably specific date range can be constitutionally overbroad. Moreover, the search and seizure of personal electronic devices raises additional concerns The seizure of such devices can give the government possession of a vast trove of personal information that the person to whom the drive belongs, much of which may be entirely irrelevant to the criminal investigation that lead to the seizures. A cell phone search, for example, would typically expose the government far more than most exhaustive search of a house because a phone not only contains in digital form many sensitive records previously found in the home, it also contains a broad array of private information never found in a home in any form. Indeed, these devices contain privacies of life. Warrants seeking to seize and search personal devices therefore create serious risk for every warrant for electronic information will become, in effect, a general warrant. Thus, the Second Circuit has held that warrants lacking meaningful parameters on the otherwise limited search of a person's electronic devices are invalid. Let's see. Give me 1 second. Okay. Again, at bottom, the core abuse that the Fourth Amendment sought to prohibit was general, exploratory rummaging in a person's belongings. That is true as to the belongings in a person's home and as to the belongings on a person's cell phone. In this case, the government sought and received authority for general exploratory rummaging through Mr. Combs' entire physical and digital life. My question is, when, like, let's say they brought up child pornography, right? And I want to see how that is applied, because do you pick and choose how much information you go through? Because and I'm just saying, like, you, whatever you find, like, you can't help as to what you will find on an electronic device. Like, you could go on to somebody's and it may appear to be something, but it may be encrypted. I hope y'all understand what I'm saying. So, mm, okay, maybe it's just me. The warrants obtained by the government in this case were virtually limitless. The government sought warrants in this case that gave it an unfettered ability to search Mr. Combs's residence, his digital devices, and his iCloud accounts. The government's list of items to be seized from his house were pages long and is stunning in its breadth. The government claimed the right to seize, among other things. So, this is what they were asking for: evidence of Mr. Combs's location or anything reflecting the location of the conspirator or witnesses, which, according to the government, seems to be mean anyone who ever worked for Combs or went to a party. Utility bills, mails, correspondence, address books, all calendars and scheduling information, including travel records, all financial, including bank statements and credit card statements, plus all cash, property deeds or titles, or anything related to property ownership, plus any evidence relating to online financial accounts. Any X toys, actually suggestive clothing, whatever that means, plus any medical supplies or other material possibly related to X, plus any bodily fluid or other material that might contain DNA evidence. Any communication or record of communication with any formal actual partners or employee of the Combs businesses, plus any communication related to the charge offenses, which was as noted, defined incredibly broadly, which any possible victim, co-conspirators, or witnesses. Corporate records included corporate organizational and ownership documents and employment records, any digital devices that may contain evidence, including phones, computers, iPads, and cameras. These descriptions were often written with catch all clauses, with regular use of phrases such as, including without limitation, and including but not limited to. The list above is thus not even a remotely complete list of what the warrant sought. It merely sets forth some of the high level categories targeted by the government. What? Okay. The government's warrants to search Combs' iCloud accounts and his cell phones were similarly broad. As to what information is sought, the government may just as well have said everything. The, out- the iCloud warrant sought the ability to search anything stored in the accounts. Example 1. The cell phone warrants, both the initial March warrants and the subsequent September warrant, sought all communication, photos, documents, calendars, location data, travel records, financial records, call records, and so on. Anything related to the subject offenses. What is wrong with that? That absolutely there's not, they're just making sure that they cover all categories, because I know for me as a business owner, sometimes I do have some of my business stuff on my business account for I use Drive. I use Google Drive. I don't see anything wrong with that request. Let me see. Exhibits 5 through 8. Let's see. But because the subject offenses were defined as including all of Combs's businesses, his household, and his relationships with his girlfriend over the past 2 decades, it is hard to think of anything that would have not been related to the subject offenses. In United States versus Way, Judge Nathan held that similarly broad warrants were unconstitutionally broad and suppressed the evidence obtained through the warrants. Way involved security fraud offenses, and the government obtained warrants to search both his residence and his place of business. The warrants broadly sought any and all records or evidence that might be related to the offense, including financial records, bills, messages, travel records, photographs, computer and cell phones, and so on. Indeed, that the broad list of items to be seized very much resembles the list in this case. So they want to be specific, but how can you be specific when you don't know exactly what you're looking for? The district court ruled the warrants were overbroad and therefore illegal. Several key reasons undergirdle the ruling. Although warrants generally identified the crimes as security fraud, the categories of documents sought were so broad and numerous as to be consistent with an investigation into almost any form of financial crime. So, I guess in this particular case, they would say, okay, let me see your accounting software, let me see your ledger, let me see your bank statements. I think you had to be more specific. And I get that. But in this particular case, how would they have known what to actually be specific about? If they say we need photos relating to this case. So if we think about the type of case with anything that's dealing with something actual, dealing with purchasing escorts, like I'm just trying for it to make sense. Like, how specific can you be in this particular type of crime? Not securities, because securities exchange, you think about financial. So I want to see, ledgers and all that other stuff. That's easy. But when you have this particular type of case, I don't see how you can be specific. More importantly, the warrants set forth expansive categories of often generic items subject to seizure, several of the catch-all variety without critical any linkage to the suspected criminal activity or indeed any meaningful content-based parameter or other limiting principle. In way, as here, the listed property was not illegal contraband, whether it was property in lawful use that the government only vaguely suggested might be related to broadly specific criminal activity. Well, I mean, it just depends, because if he was indeed having these people, and the ex workers go from one, or these women that he allegedly assaulted and raped and all this other stuff, if they was bouncing from Miami house to the yacht to your Los Angeles home, that still would be considered, that's trafficking, right? But I would be searching your house because I want to know if there's cameras. I want to know if there's secret dungeons. I want to know if there's any type of DNA that's been left in the house. It's just, that's my thought process. Anyway, as here, the warrants lack any meaningful temporal limitation on the items that could be seized. At bottom, the warrants in way violated the Fourth Amendment because they authorized the seizure of sweeping categories of materials and lacked any practical tool to guide the search agents in distinguishing meaningful between materials or potential evidentiary value and those obviously devoid of it. As Judge Nathan concluded, the warrants are in function, if not in form, general warrants. And that was in the Way case, United States versus Way. The same here is true. Indeed, the warrants here are even more infirm, whereas the warrants in Way authorize unbounded search of the defendant's business affairs. The warrants here authorize unbounded search of Mr. Combs' business and personal affairs. He's still trying to say that everything that he was done actually was consensual. So why are you trying to use any of that evidence if they were consenting adults? The warrants here allowed the very sort of general exploratory rummaging in a person's belongings that the Fourth Amendment forbids. Nor can the government evade the Fourth Amendment's limits simply by stating that Mr. Combs was himself a sort of criminal racketeering enterprise, and therefore all evidence of his business and personal life was relevant evidence of a crime. If such a rhetorical trick were allowed, the Fourth Amendment would lose all meaning. Lord Chief Justice Holt once famously challenged a prosecutor. Hold, what are you doing now? Are you going to arraign his whole life? That is exactly what the government did here. It charged Mr. Combs' whole life as a racketeering enterprise, and then it obtained warrants to search his whole life. The iCloud warrant, the warrants to search his houses, they said houses, the cell phone warrants, and the park height warrants were individually and collectively exactly the sort of general warrants that the Fourth Amendment sought to prohibit. In conclusion, this court should suppress the evidence and all its fruits obtained from the warrants to search Combs's residence, his person, his iClouds, and his devices. These warrants were unconstitutionally broad, and in the alternative, and at a minimum, this court should order a Franks hearing to hear additional evidence and determine whether the warrants were improperly obtained through deception. Alexandra Shapiro. Mm, 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 mm. That was long, but that was juicy. That was very juicy. Oh, I forgot. I forgot about the declaration. So that was his motion to support. Now, very quickly, let's tap into the declaration for Tini Guerreros. This is the man who is overseeing all of the evidence that is coming from the government. He is a partner at Agnifilio Law Firm. He's a licensed, good standing in the states of New York and California. He's admitted in the Southern District of New York. He submits this declaration in support of Sean Combs' motion to express the evidence and request for a Franks hearing. Let's see, he says in this case the government has obtained. So we already know about the search warrants. All right. Oh, he attached the warrants? Nope. I don't think I got access to get the warrants. I don't think we will ever have access to the warrants. Darn it. Mr. Combs is requesting that all evidence and fruits from those warrants be suppressed. Over the course of this case, the government has provided the defense with discovery of various evidence obtained from different sources. This includes evidence obtained through the search warrants referenced above, as well as evidence obtained through other warrants. It also includes evidence the government has obtained through other means, some of which the government used in support of its application for the search warrants. The government has also communicated to the defense and correspondence various other matters related to the search warrants. For my review of the discovery, it appears that the government began its criminal investigation in this matter. Ugh, I wish we knew that date. Following the government's disclosure of the warrants to counsel on October 7, 2024, I learned that on or about December 15th, 2023, victim 1, Cassie, blank. I've since learned that those devices included an iPad and a MacBook Air. So I'm assuming that Cassie turned over those items to the government. The government has been unable to extract the iPad. The remaining devices contain, okay, and I think we know what those devices entailed because that's how they probably ended up with those 9 or 10 freak off tapes. I have reviewed something twice, once on or about November 20th and once on or about December 13th. I know those dates automatically. He talked about the freak off tapes. You viewed the tapes twice, you just nasty. Okay, so these are text messages. After the government received blank from the devices provided by victim 1, the government obtained a search warrant to search Combs' iCloud account. So Exhibit 1 is the warrant for Mr. Combs's iCloud accounts associated, and it has the Apple IDs. The warrant return contained blank. This account also contained additional messages between Combs and other alleged victims, as well as witnesses. True and correct copies. Okay, those are the messages. I don't think they're going to show us that. So these are the messages. Then after they obtained that, that's when they got additional search warrants. Okay, so by this time it saw additional search warrants in March 2024. The government already possessed a large amount of relevant evidence, including the freak off videos and the messages described above. They later executed warrants which returned text messages. Oh, it was a lot of text messages. The government has made multiple Brady disclosures in this case. Mr. Combs' motion references blah blah blah, and I attest that the motion accurately quotes the statements. Mr. Combs' motion references a publicly filed lawsuit and demand letters for civil claims sent by Mr. Combs by blank. I have not attached these demand letters as exhibits, and in abundance of caution, as they were sent to counsel for Mr. Combs for settlement purposes. However, Federal Rules of Evidence 408, paragraph A2 and B, allow their use in a criminal proceeding. Nonetheless, I attest that Mr. Combs' memorandum of law accurately describes the monetary demands made in these letters. Oh, wait, who sent him demand letters? I believe Cassie sent him demand letters, but who else? All right, well that's it. That's it. That's all. I didn't see any and I know a lot of stuff is probably under protective order, but I did not see anything that showed any exhibits. Hold on, I go back on here. Nope, I didn't see no exhibits on here. No, so that's it. So Anthony Ricco, whatever he knows, he got up out of Dodge. And Diddy is now saying, I don't want y'all to use none of that evidence that y'all obtained in that raid. I don't want y'all to use any evidence that Cassie has given you. I don't want y'all to use none of the affidavits from these non credible witnesses that y'all claim. Because apparently, what Sean is saying is that they left out some important information on those affidavits. Because if they included it and they presented before the magistrate, he would have probably said, this is not enough. This is not enough to grant this warrant. This is a lot of information to unpack. Y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe to this channel. You all be blessed and have a good night. Bye.